Welcome to Prediction News Update. My name's Chris Gerlacher. I'm the senior political reporter and industry analyst for Prediction News. And we've got some drama in Massachusetts to cover today. Before we get into it, like this video, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. I'm here as always with Daniel Wallach, appellate lawyer extraordinaire, and the legal mind pulling back the curtain and helping us understand what's going on in all of these federal courts. Dan, the Massachusetts State Attorney General brought a suit against Kalshi, accusing it of being an unregulated form of sports betting masquerading as a finance company. Is this the beginning of the floodgates opening of the states trying a new legal tack against Kalshi and the prediction market industry?
Yeah, that's a great question, Chris. I think we're beginning to see a shift in strategy, because prior to the filing on Friday, the states were content to basically watch the New Jersey, Nevada, and Maryland cases play out. But the problem with those cases is that they're framed in Kalshi's preferred, argument, which is not addressing or tackling the ultimate question of whether these contracts are legal, but rather Kalshi is shoehorning it or narrowly framing the case as one of exclusive jurisdiction. And the states are playing in Kalshi's sandbox and have lost 2 out of the first 3 preliminary injunction motions. So I think the states are seeing the momentum shifting in Kalshi's favor and have decided to do something about it, because ultimately these are state law issues that the states want to press. They want to go on the offense and not be forced to play defense and be stuck in a box on the question of preemption. So it was inevitable, I think, that states like Massachusetts and others would stop with the idea of giving Kalshi advance notice and saying, oh, you got to stop in 10 days. And then Kalshi would immediately respond by filing a lawsuit in federal court. I think now we're going to begin seeing states turn a little bit to the element of surprise and go on offense, press the state law issue, and try to put Kalshi on its heels with motions for preliminary injunction. So this is the first indicia of that happening. And now, over the course of the last couple of days, there have been a lot of legal wranglings over the issue of venue and jurisdiction.
Yeah, well, let's get into that, because just this morning, in that case, we moved from state court to federal court. How did that happen? What happened there?
On Friday, the Massachusetts Attorney General filed claims in the Superior Court in Suffolk County, which covers Boston, and the Attorney General filed claims that were exclusively under state law. On Monday, Robinhood, anticipating a possible suit by the Attorney General against Robinhood because their contracts are facilitated through the Kalshi exchange. What happened the day after is that I think it was the first step in a 2-step process to get the case out of state court and into federal court. And Kalshi is arguing that even though the Mass Attorney General framed those claims exclusively under state law, it's really a federal cause of action in disguise, because the CFTC regulates event contracts that are traded on DCMs, and Kalshi's sports event contracts are traded on its DCM, and therefore federal jurisdiction and federal regulations pervade this entire set of transactions. And to the extent that there's any cause of action at all, it belongs in federal court, not state court. So it's basically the mirror image of the same kind of preemption arguments that Kalshi argued a little bit more than a week ago in the Third Circuit, and have been arguing, or has been arguing in the Nevada courts and the New Jersey courts. But the preemption analysis is a slightly different twist when you're fighting over the issue of whether the case is removable to federal court and should stay in federal court, as opposed to whether state law is trumped by federal law. There's a lot of overlap, and there is some confusion over the precise type of preemption analysis. But basically, in a nutshell, Kalshi is arguing and will be asserting that these claims, to the extent they belong anywhere, are in federal court, should be in federal court, because the CFTC has been granted exclusive jurisdiction over event contracts traded on DCMs, and the states or the Commonwealth's claims really are federal law claims dressed up as state claims.
Okay. And how long does the Massachusetts have to respond or appeal or try to bring this case back to state court?
Well, they normally, most respondents to this wasn't a motion, this was a notice of removal that Kalshi filed to automatically transfer the case from state court to federal court. So there's no response really due, but what the state of Massachusetts or the Commonwealth of Massachusetts had already set up in the Superior Court was that they got a date on their emergency motion for a preliminary injunction. When the state attorney general filed the lawsuit on Friday, simultaneously with the filing of the complaint, the AG's office filed an emergency motion for a preliminary injunction to basically force Kalshi to immediately enjoin or to enjoin Kalshi from offering any of its event contracts within the Commonwealth of Massachusetts. That PI motion was backed up by 4 affidavits, extremely detailed factual allegations, and a detailed legal analysis. The Superior Court the next day, or Monday morning, scheduled that emergency motion for a hearing next Monday, September 22nd at 10 a.m. in Boston in the Superior Court. So Kalshi's move to file a notice of removal essentially wrests jurisdiction, at least temporarily, away from the Suffolk County Superior Court and vests it in the Massachusetts Federal District Court. And what does that mean for the hearing date? It means that the hearing is not going to happen unless the state attorney general's office does something this week to try to get the case rerouted back to state court. And one of the tools in the state attorney general's quiver that they might exercise and deploy here would be something called a motion to remand, which would be requesting that the federal court kick the case back to the state court because there isn't a viable basis for federal jurisdiction. But the hearing date is only 6 days away, so any motion for remand would have to be filed on an emergency basis. And as of the end of business, close of business on Tuesday, several hours after Kalshi's filing, the state attorney general's office has not yet filed a response or any type of motion for remand. But I would expect the state attorney general's office in the next day or two to be heard in federal court, either by requesting oral argument on the issue of preemption and where the case belongs, or alternatively, ask the court to hear the Commonwealth's motion for a preliminary injunction, but instead of having it heard by the Superior Court, it gets heard by the federal court judge at some point next week. So I would imagine we're on a track to having some type of federal court hearing next week, and I suspect that hearing will be focused on where this case belongs jurisdictionally. Now, it could either be a status conference that the court convenes, or the court can hear argument on the removability of the case. But I think it would require as a prerequisite that the Commonwealth, at the very least, file a motion to remand the case back to state court, and then the federal court might hear it on an expedited basis.
And for Kalshi, how does the case progress differently if it is heard in state court versus federal court?
Well, they have a slightly different posture. Instead of having moved for preliminary injunction as they've done in Nevada, New Jersey, and Maryland, now they're the recipient and the target of an offensive motion for a preliminary injunction brought by the Commonwealth of Massachusetts. So it's not the same case as the Maryland, Nevada, New Jersey cases. So in all likelihood, Kalshi will be forced to argue a different type of preemption issue in defense to the claims brought by the Commonwealth of Massachusetts. So the overarching or the commonality in these various preemption approaches is that regardless of whether it's field preemption or defensively it's called complete preemption, I think Kalshi will need to be able to demonstrate to the federal district court judge that the CFTC has exclusive jurisdiction over any contracts traded on CFTC designated exchanges, including sports event contracts traded on the DCM. So I think we'll have some resemblance of the arguments and issues that were litigated in the other courts taking place in a Massachusetts courtroom probably at some point next week. The standards are somewhat different, but there is significant overlap between arguing field preemption when you initiate the lawsuit in federal court versus arguing complete preemption when you're trying to sustain the removability of the case from state to federal court. But the additional factor that Kalshi will need to be able to demonstrate, besides the CFTC's exclusive jurisdiction and whether that covers sports contracts, is whether federal law provides a parallel cause of action for the same alleged wrong. And I'm not sure that the Commodity Exchange Act provides the Commonwealth of Massachusetts with any type of statutory cause of action based on the alleged wrongs taking place within the Commonwealth of Massachusetts. So we've yet to hear from the Commonwealth. They haven't filed their remand motion or their counter argument, but we're likely facing either a hearing next week over the issue of remanding it back to state court, which will focus on issues of preemption or complete preemption, or that potentially could be folded in to a broader hearing on the state's motion for preliminary injunction. So I just got out of court in Philadelphia last week, and in all likelihood, the road trip may be headed to Boston.
Okay. And how long do we have to go through these cases in Massachusetts until we learn whether sports contracts are getting blocked in the state or whether they're going to remain available there?
It depends how the court rules on the preemption issue. If the federal court kicks the case back to state court, grants the motion to remand, I think the Massachusetts Superior Court, based in Suffolk County, has a pretty easy, clear path to finding that Kalshi's sports event contracts violate state law. I mean, the battleground here isn't legality. The battleground is who has jurisdiction. And right. If Kalshi can play in its own sandbox and keep the case in federal court on the argument that the CFTC exclusively regulates everything, that's basically a victory for Kalshi. Mm-hmm. But if they lose on the motion to remand and it gets kicked back to state court, how do you defend the legality of these contracts under state law if you're forced to litigate in a state court applying state law when the legal claims are essentially that Kalshi is violating Massachusetts gaming and sports betting laws? So the entire battleground for Kalshi is keeping this case in federal court next week. And to the extent that argument fails, I don't see how they prevail in the Massachusetts case. And in all likelihood, the Superior Court would grant the Commonwealth's emergency motion for preliminary injunction, and force Kalshi to cease their operations or cease accepting, event contract purchases and sales anywhere within the Commonwealth. But the real battle is over jurisdiction and the issue of preemption. And depending on how that plays out, that can in turn determine how quickly the case winds its way to a conclusion. But this is like a national battle. This isn't just confined to Massachusetts. We're going to eventually see more cases filed, like the Massachusetts Attorney General filed. We may see states like Arizona, Ohio. I just can't imagine, given how poorly the early results have been for the states, that they're going to hitch their future sports wagering revenues and to place the fate of the licensed industry completely in the hands of the litigation strategy undertaken by New Jersey and Nevada, which to date has not been very successful. So I think the states are going to begin, just as the tribes did, to start forging their own path and creating their own self-determination, and not depending on New Jersey and Nevada to dictate the outcome.
Well, let's talk about Nevada real quick. Kalshi and the state of Nevada have filed a brief saying they failed to reach an agreement about how to conduct discovery, which
no surprise there. Yeah. I mean, that is like they were supposed to file a scheduling order, a basic, discovery order that sets the pace of discovery and sets forth some of the preliminary agreements. They couldn't agree on anything.
That sounds about right. That's how their fight in Nevada started, at least over discovery. What are the next steps there then?
Well, the next steps are the court in Nevada has to decide whether to hold the motion for summary judgment filed by Kalshi in abeyance in order to permit discovery to take place. How long should the discovery period be? What issues are going to be fair game in discovery? We don't know whether the court is going to allow just a little bit of discovery or a whole lot of discovery that could take up much of the next 6 months. What I would expect to see in the Nevada court are constant battles over every single piece of discovery that Nevada wants to take. They're going to want communications between Kalshi and the CFTC, communications with Brian Quintenz, communications with Donald Trump Jr., with the Trump administration, everything and anything that can bolster Nevada's defense here. And I don't think Nevada envisions only taking a limited amount of discovery, because you've got two Nevada parties. You have the Nevada Gaming Control Board and the Nevada, Gaming Commission, alongside another party, which is the Nevada Resort Association, right, which not just, the casinos. They didn't just file an amicus brief. They formally intervened in the case. And then on top of that, the Nevada gaming regulators have turned to the prestigious law firm of Mayer Brown and their Supreme Court practice to take over the case or work side by side with the Nevada Attorney General. And I think that is a brilliant tactical maneuver, because part of the reason why the states have gotten off on the wrong foot is their refusal to hire nationally renowned powerhouse litigation counsel to do battle with Milbank over these nuanced federal issues. So the states got caught flat-footed right out of the gate, but now they have Mayer Brown representing the state, the Nevada Resort Association, ably represented by John Gruden's legal team. So this is shaping up to be a very hotly contested battle over the length of discovery, the scope of discovery, and I would expect there to be constant firefights over who can be deposed, what issues can be pursued. And as a consequence of this type of motion practice, which is going to arise over just about every little detail, I think this is going to delay the resolution of the Nevada case, at least until the middle of next year. So putting aside the motion for summary judgment, that's not going to be decided for quite a while. I think we're looking at a mid-2026 resolution at the earliest, in order to accommodate a limited period of discovery, even a couple of months, followed by motion practice on the MSJ, and then the court's ultimate ruling. So ironically, the first case filed was Nevada, but it may be the final district court. It already is the final district court, because the Third Circuit and the Fourth Circuit have already taken over the New Jersey and the Maryland cases, and the Nevada case, until this Massachusetts filing, was the lone federal trial court case that was still proceeding along. And the pace of this is going to slow down considerably as the parties dig in over various discovery battles and try to take depositions. So I think a very important juncture in the case for the states was being able to win, at least for Nevada, being able to win the right to take discovery from Kalshi, because in Kalshi's best case scenario, they would have denied the states any discovery and pursued summary judgment on as naked of a record as they had to support their motions for preliminary injunction. And if there were no discovery available, why would the result change? So this is a significant swinging of the pendulum in the state's favor, because now the states are going to be able to bolster some of their arguments as to irreparable harm, the costs and inconvenience of geolocation. Pretty much everything is fair game in Nevada right now.
And how much is Nevada discovery going to matter if the Third Circuit and the Fourth Circuit can issue opinions even before discovery is completed?
Well,
if the delays are potentially that long.
Yeah, I mean, there's very little doubt that the Third and Fourth Circuit rulings are going to precede any Nevada district court ruling. So what would happen is now you have a federal court of appeals precedent that could influence the judge on how to rule in this case. The judge has already preliminarily ruled in Kalshi's favor based upon a very threadbare amount of briefing at the onset of the case. And to the extent some of the decisional law goes in the state's favor, as well as some of the discovery that's elicited, that could potentially signal a change in the state's fortunes in Nevada. But that would require Third Circuit ruling and Fourth Circuit ruling potentially going in the state's favor. And right now, it doesn't look so good for New Jersey and the Third Circuit. And we've yet to receive any briefing from Kalshi on its Fourth Circuit appeal, with respect to its lone loss in the federal courts, which is the Maryland federal court ruling, which focused extensively on the issue of congressional intent and less so on the scope of the definition of the term swaps.
Yeah,
So
they did not get caught up arguing the CEA text.
No. That was a losing battle for New Jersey. The Maryland federal court ruling is a textbook example of how states should be arguing their side of the case. This all boils down to, if you're the states, this boils down to the issue of congressional intent and not the textual language that's in the definition of the word swap, viewed against the backdrop of what Congress may have been thinking in 2010 or even before that, the existence of a suite of other federal laws such as the Wire Act, PASPA, IGRA. It becomes much more implausible that Congress would have silently authorized the issue of sports betting to be traded on an exchange like the CFTC when it had a crystal clear federal policy of disfavoring interstate sports gambling through these other federal statutes. So, the real core of how these cases could turn out is where the courts are going to place the lens. Are they going to focus on the textual definition of the word swaps, or are they going to take a sort of a magnifying glass and focus on the issue of congressional intent, the legislative history, and what Congress may have intended when it enacted the Dodd-Frank Act, given the congressional record testimony, the other federal statutes on the books. So there are different analytical paths that the courts can take here. I found that the Maryland court focused on congressional intent. The New Jersey Third Circuit Appellate Court was more focused on the minutia or the breadth of the definition of the term swap. So depending on how you attack or analyze the issue could dictate the potential outcome of the case. So it's really important for Nevada to have the benefit of a Fourth Circuit ruling and potentially a Third Circuit ruling that could create a different analytical pathway for the Nevada judge to take when he decides the issue of summary judgment.
And Kalshi had there was a new tribal group in California that filed another brief against Kalshi in the last few weeks too, right?
Yep. The three Northern California tribes followed up their lawsuit filing with a motion for a preliminary injunction. They took a while to file that PI motion, but when they did, they've essentially signaled that they want a court to immediately order Kalshi to refrain from offering event contracts tied to sporting events anywhere on those three Indian reservations. And the issue, or at least the motion for a PI, while it's not being brought on an emergency basis, it is being brought on an expedited basis, and the court is going to hear oral argument on that motion in San Francisco Federal Court on October 23rd. There's a briefing schedule that's been established. The response from Kalshi is due on October 2nd. The tribal reply brief is due on October 16th, and then oral argument on the 23rd. If the tribes prevail on this issue, and the one key distinction between the tribal case and the state's cases is that the state's cases depend on the application of state gambling laws, whereas the tribal case hinges on the application of the Federal Indian Gaming Regulatory Act and a potential violation of the Federal Lanham Act. So the tribal cases avoid the questions of preemption that acted as roadblocks for state enforcement of their gambling laws. That issue is not in play in the tribal cases. The tribal case focuses squarely on the issue of whether these event contracts intrude upon tribal sovereignty within their own Indian lands in violation of IGRA. And that's a much tougher argument for Kalshi to be able to resist. It's no longer a matter of who has exclusive jurisdiction. It's whether these contracts, to the extent available on tribal lands, violate tribal exclusivity and tribal sovereignty under IGRA.
And I know I've seen Kalshi or lawyers affiliated with them begin to argue already that IGRA and laws like that give the tribes the exclusive right to regulate gaming, but Kalshi is going to push back and say, well, we're finance, we're not gaming. How effective do you think that line is going to be in federal court?
Well, Kalshi, I don't think it's going to be too effective of an argument in light of the fact that Kalshi admitted that its event contracts, or Kalshi admitted that gaming contracts are synonymous with sports gaming. When Kalshi litigated against the CFTC in the congressional control case, where they were in a lawsuit with the CFTC over Kalshi's attempt to offer event contracts tied to the outcomes of political elections, the CFTC argued that they're banned under the CFTC's rule banning gaming contracts, and Kalshi in turn argued gaming does not cover political elections. It only covers games, sporting events like the Masters golf tournament, the Super Bowl, the Kentucky Derby. So Kalshi admitted in another parallel, or no longer parallel, but in a prior federal proceeding, that gaming was synonymous with event contracts on sporting events. That's what Congress was focused on, and that's what the CFTC was focused on when designing both the special rule and the regulatory prohibition against gaming contracts. It was designed to deal with the issue of sporting events and nothing else. Now we're dealing with sporting events, and that's precisely what the tribal groups are complaining about in their San Francisco federal court lawsuit. So this is another instance of where Kalshi's prior admissions and prior inconsistent statements in a different federal court action may come home to roost against them, and it'll be interesting to see how Kalshi defends against some of those prior statements when it's their turn to file a brief on October 2nd. But this is not necessarily a slam dunk for the tribes either, because they've got to show that they're a competitor. Kalshi is in the realm of sports gaming conducted on a CFTC regulated exchange. The tribes in California don't offer any form of internet gaming. So how broadly or how narrowly does a federal court in San Francisco view what the tribes are offering versus what Kalshi is doing when California doesn't have legal sports betting and the California Indian tribes don't offer sports-related contracts even on their own lands? They offer only a land-based casino product, slot machines, and other types of table games. Is that close enough to give the tribe standing to enforce IGRA against Kalshi's sports-related event contracts? So there are some issues of standing. There are some issues of whether there's a direct conflict or not. And we're still relatively at the early stage of the briefing schedule, and we'll analyze the quality of those arguments as we get closer to the October 23rd argument date. But until October 2nd, we don't understand yet how Kalshi will be framing that argument in opposition to the motion. But that's certainly something to look out for, the question of whether the tribes have legal standing to enforce IGRA against a type of gaming which they don't even offer and which California doesn't even allow. But I think it might be close enough where it's competition for the gambling dollar. Right. And that might be the overlay here that is the thread that connects the two types of gaming.
Right. I mean, that covers the big legal updates we've had in the past few weeks. Is there anything else that we've missed? Anything to end on before we wrap? This story is unfolding day by day. I mean, until a couple of days ago, Massachusetts wasn't even in the game. The tribes hadn't yet filed their motion for a preliminary injunction. So I think what the states and the tribes are understanding and realizing now is that they've got to start playing offense. And the tribes and now Massachusetts are going on the offensive. And I would expect other states and potentially other tribal groups, maybe even in Florida, could even be the Seminole tribe. I have no prior knowledge or inside knowledge about that, but I would be very confident in predicting that there will be other states involved in litigation against Kalshi in relatively short order, and potentially other tribal groups. I think given how the first couple of cases have gone, I think it's imperative that the states and tribes act now before everything gets away from them, based on how the early outcomes have transpired in Nevada and New Jersey, because those decisions don't really have binding effect
in some of the other circuits, like the First Circuit, which is where Massachusetts is, or the Second Circuit, or the Fourth Circuit, we'll begin to see some more litigation action initiated by other states, other tribes, and potentially maybe even other stakeholders. So I would say that that's something that I'm watching very closely here, because now these proceedings are beginning to expand on almost a national basis.
Yeah. We'll be watching for the flood of cases to begin coming against Kalshi from the states and the tribes.
Knock on wood, God willing.
Well, if you like what you heard today, like this video, subscribe to our YouTube channel at Prediction News, follow us on X at Prediction News. Dan, thanks again for breaking this all down for us.
Thanks for having me back, Chris. It's been a frenzied past week and a half, and much more to come. So stay with us, and we're going to keep following these stories, and just giving you our analysis and updates as quickly as they happen.